Good afternoon. Distinguished legal luminaries, respected members of the faculty, legal scholars, delegates, and my enthusiastic fellow student companions. Welcome back to the afternoon session of Day 2 of our national seminar. As we reassemble for this afternoon session, we step into an elite intellectual territory that bridges academic tradition with the relentless march of modern technology. Our centerpiece for today is a highly anticipated panel discussion centered around a theme that is not just contemporary but absolutely critical for our survival as future legal professionals. The theme for the session is Low Tech and Education, Reforming Legal Pedagogy for the Digital Future. Ladies and gentlemen, we live in an era where artificial intelligence drafts complex contracts, blockchain secures legal registries, and predictive analytics shape corporate litigation strategies. The traditional ivory towers of legal education must adapt to this digital paradigm shift. To explore how we can re-engineer our law schools, classrooms, and clinical methods to prepare students for this landscape, we have assembled an extraordinary panel of pioneers spanning across frontier law tech academia and digital rights litigation. To formally set this afternoon's proceedings into motion, I invite our dynamic student leader, Ms. Adina A., the joint convener of Bhagat Singh Study Circle, to deliver the welcome speech. Adina, the stage is yours.
Good afternoon, everyone. It is my distinct pleasure and privilege to welcome you all to this insightful panel discussion on law, tech and education, reforming legal pedagogy for the digital future. The session is a cornerstone of our national conference. Today, as technology continues to reshape every aspect of our lives, legal education stands at a critical crossroads. The integration of artificial intelligence, legal technology, digital research tools, and online learning platforms is fundamentally redefining how law is taught, understood, and practiced. This afternoon provides us with a vital opportunity to explore these emerging challenges and possibilities. We are truly honored to have with us an eminent panel of experts who brings a wealth of academic, professional, and practical experience to this conversation. Please join me in extending a very warm welcome to our distinguished guest, Dr. ARUL SCARIA, Professor of Law at NLSIU. I welcome you, sir. Next, I welcome Dr. PRASANTH SUGATHAN, Advocate at the High Court of Kerala and a leading technology lawyer. Welcome, sir. And next, I welcome Dr. Anishvi Pillai, Associate Professor at the School of Legal Studies, KUSAT. Welcome, sir. We are equally delighted to welcome Mr. KURUVILA SABU CHRISTY, Assistant Professor at St. Dominic College of Law, Kanjirappalli, who will be moderating the session. We appreciate your willingness to guide this important conversation today. Finally, a hearty welcome to our all distinguished delegates, academicians, legal professionals, researchers, students, and guests. Your presence enriches this conference and drives the meaningful dialogues we hope to achieve. Once again, a warm welcome to you all. Thank you, and I wish everyone a highly fruitful and engaging discussion.
Thank you, Adina, for your warm welcome. Now, it is my absolute privilege to introduce our co-panelists, three outstanding experts who represent the true vanguard of the tech-law convergence in India. Our first panelist is an internationally revered legal academician, Professor Dr. ARUL SCARIA, Professor of Law at the National Law School of India University, Bangalore. Dr. SCARIA is a globally recognized authority on intellectual property law, open science, digital commons, and the intersection of technology policy and openness. Having shaped frontier tech law research at India's premier national law university, his insights are absolutely vital to understanding how institutional curricula must adapt to technological disruption. Ladies and gentlemen, please welcome Dr. ARUL SCARIA to the dais. Sir, please. When cutting-edge tech policy meets constitutional rights, it is settled in our courtrooms. Our second panelist is Advocate PRASANTH SUGATHAN, a premier technology lawyer practicing before the Honorable High Court of Kerala. Advocate SUGATHAN has spent years navigating digital rights, cyber security challenges, and privacy litigation on the ground. He knows exactly where outdated statutory laws crash against accelerating tech, making his litigation experience indispensable for reforming how we teach law. Please join me in welcoming Advocate PRASANTH SUGATHAN. Sir, please welcome to the stage. Completing our panelist lineup is a phenomenal academic mind, Dr. Anish V. Pillai, Associate Professor at the School of Legal Studies, QSAR. Known for his expansive legal research and deep focus on institutional legal reforms and contemporary laws, Dr. Pillai understands the administrative, structural, and pedagogical shifts needed to execute real curriculum reform within our university systems. Please join me in welcoming Dr. Anish V. Pillai to the dais. Sir, please. To guide a discourse of this magnitude, we require a person who deeply understands both the nuances of classroom pedagogy and the hard expectations of professional practice. We are profoundly privileged to have exactly that profile in our moderator for today. Advocate KURUVILA SABU CHRISTY, esteemed Assistant Professor at St. Dominic College of Law. Professor KURUVILA brings a rare and balanced perspective. He stands with one foot firmly rooted in rigorous academic mentorship and the other in active courtroom practice. I request our moderator to kindly ascend the dais and take the chair. I am certain that this session will challenge established conventions and chart an innovative path forward for legal education in India. Without further ado, I hand over the proceedings of this session to our moderator, Advocate KURUVILA SABU CHRISTY, to lead the discussion. Sir, the floor is yours.
Thank you so much. Thank you. Very good afternoon to you. I know that me including moderator as well as the esteemed panelist, you would be thriving to hear from all of us. This is a very peculiar topic to be discussed with you, and I thank from my part and our panelists to the organizers, a big thank to the organizers to involving such a brilliant topic in the national conference. Thank you so much. Regarding the topic, moving forward, welcome, sir. I think the introduction part has been already done by the. Thank you, sir. Thank you, sir. So, regarding this topic, I would like to start with two simple topics, to be honest. Regarding law, legal, tech, education, then how to reform or how to involve the digital space into our legal education and the pedagogy. So regarding that, I will try to put forward two situations just for a start. Honestly, I'm not being a panelist or going to in depth with the topics. I would be handing over that area to our esteemed panelists. I would start with two occasions. First one is, I have seen an increase in the number of paper presentations by the students, their willingness to attend moot court competitions. So while during my time, probably there would be out of 80 students, there would be like 30 students who would be very engaging in moot court activities, paper presentations and such things. But I have seen an improvement in the number of students who are engaging in those activities right now. That is the first open point I need to give you. I will connect to the situation right now, or the topic we are discussing. And the second point I would like to introduce is a very interesting one. I would like to introduce the term prompt to you, prompt. I think this is a very common term to you, because right now you would be all following the need of a good prompt. So if you are a social media addict or you are being into a social media platform, right now you are in search for the best prompt. So I would relate this prompt to all the artificial intelligence or the so-called AI mechanisms you can relate to, so that you can get what to be done, anything to be done from the AI part. So you just need to find out the only prompt which suits you, so that you can introduce yourself to the machine, so that the rest of your work would be done by the machine itself. So finding the best prompt, so that you don't even want to go forward with the next prompt. So you have to evaluate the best prompt initially so that you don't want to do anything more. So I'm introducing these two areas so that let us find out the importance of the AI or the artificial intelligence or the digital platforms so that to be introduced to our legal pedagogy and to reform ourselves, because there is no going back from the AI. We cannot. I think it has to be incorporated. So it's open for discussion. So it is up to us not to avoid it, but to incorporate it. But in what way would be the biggest challenge before us? And I would like to welcome our first discussant, Dr. ARUL SCARIA sir. Sir, very happy to have you. Sir, please.
Okay, so very good afternoon, everyone. ആദ്യം തന്നെ ഒത്തിരി സന്തോഷമുണ്ട് ലോ കോളേജിലേക്ക് തിരിച്ചു വരുവാനും ഇവിടുത്തെ മാറ്റങ്ങൾ കാണുവാനും. ബിൽഡിങ്ങുകൾ ഒത്തിരി മാറിയിട്ടുണ്ട്, സ്റ്റുഡൻസ് ഒത്തിരി മാറിയിട്ടുണ്ട്. എനിക്ക് തോന്നുന്നത് ആദ്യമായിട്ടാണ് ഞാൻ ഇത്രയും യൂണിഫോം ഇട്ട കുട്ടികളെ ലോ കോളേജിൽ കാണുന്നത്. ഞങ്ങൾ പഠിക്കുന്ന സമയത്ത് യൂണിഫോം ഉണ്ടോ എന്ന് പോലും എനിക്ക് ഓർമ്മയില്ല. ഞാൻ എൻ്റെ ഓർമ്മ ശരിയാണെന്നുണ്ടെങ്കിൽ ഞങ്ങൾ പുറത്തേതോ എക്സ്റ്റേൺഷിപ്സിന് പോകുന്ന സമയത്ത് മാത്രമാണ് ഞാൻ യൂണിഫോം ഇട്ടിട്ടുള്ളൂ എൻ്റെ ഓർമ്മയിൽ. അപ്പോൾ ഒത്തിരി മാറ്റങ്ങൾ നടക്കുന്നുണ്ട്. അത്തരമൊരു സമയത്ത് ഇങ്ങനെ ഒരു ടോപ്പിക്ക് ഡിസ്കസ് ചെയ്യാനായി ഇവിടുത്തെ ഇങ്ങനെ ഒരു ടോപ്പിക്ക് ചൂസ് ചെയ്തതിന് ഞാൻ ഒത്തിരിയധികം ഇവിടുത്തെ സ്റ്റുഡൻസിന് നന്ദി പറയുന്നു. ആൻഡ് സമൺ ഈസ് ഓൾസോ റിമൈൻഡിങ് മീ ദ ഫാക്ട് ദാറ്റ് മേ ബി പീപ്പിൾ ഫ്രം അതർ സ്റ്റേറ്റ്സ് ആർ ജോയിനിങ് us. So I will also switch to English for the benefit of everyone who is joining either offline or online. So a big thank you to the organizers, particularly the Bhagat Singh Study Circle and the College Union for organizing discussion on a topic like this. So before coming to the discussion, I was having a chat with a law student. I don't want to name the person because she or he is also representing many of the people who are sitting within the room. And the very specific question which I was asking the student was, what are the 3 reforms you would like to see as a student within this particular institution? And the 3 things which she mentioned were quite interesting. One, of course, is that, yes, maybe we should focus a little bit more on the infrastructure. Cleanliness could be improved. Second was a very interesting thing because the person said that that person would like to see more attendance of her peers within the classroom. The third was, as it stands now, teachers are currently focusing on finishing the syllabi before the exams. Again, I mean, there is enormous amount of uncertainty as to when exams will happen. And the student was suggesting that maybe we need to change. But of course, to me, something more was missing here. Something maybe more fundamental was missing in this conversation. And before I go into that, maybe I should also say that I asked the same question to one of the leading large language models today, that is Cloud A, and the very specific prompt. Again, Professor KURUVILA mentioned about prompts earlier. The specific prompt which I used was, imagine yourself as a first-year law student, and what are the 3 reforms you would like to see in your institution? Again, all of us know here that whatever a large language model is producing is based on things that are already available. So I presume that the response which we are seeing here is based on tons of data which the large language model has used for training. The interesting bit is the first response says that we have to dismantle the rote learning culture in examinations. Second, mandatory clinical exposure from year one. Third, a transparent and accountable grievance mechanism. Now, one of the things which I want all of you to do is, when I initially asked that question, I am sure at least, if not three, at least one or two reforms might have also come to your mind. How many of you actually thought about something like these three changes which a large language model is suggesting based on whatever it has been trained on? But what this should also force us to rethink is, how are we going to stay relevant in a world of large language models? Each of you who are sitting here is investing maybe 5 years of your lifetime or 3 years minimum in education. And at the end, we might want to ask ourselves, how are we going to differentiate ourselves from anything which a large language model can produce? So in this regard, it's also a good idea to see what some of the recent reports are suggesting. And I will start with maybe 2 reports that might indicate certain positive things. So one is a study that was conducted by MIT last year. And the MIT study, not too surprisingly, tells us that models continue to hallucinate. And of course, I mean, in the specific context of legal practice, we are concerned about hallucination of case laws. In other words, yes, these models will definitely throw up cases that are not in existence. And it has even pushed the most, I would say, famous law firm in the world into crisis. Some of you might have read about that particular news piece. Just like 1 month back, the highest billing law firm in the United States had to render apology because some of the submissions they made had hallucinations. The second is also interesting. They point out that the models are struggling when they are attempting to synthesize information which are scattered across statutes, regulations, and judicial decisions. So if there is a one point, pickup point possible, these models will excel. But if the concerned question requires a careful cross-review of laws, regulations, and judicial decisions, maybe things will get a little more tricky. And third, it was also pointing out that the models are still struggling to navigate gray areas of law and reason about novel questions. Again, not too surprising because most of these models are trained on data with a certain cutoff date. Of course, today that issue is addressed to some extent because they are also now integrating the training data with real-time source results. So the issue has been addressed to some extent, but still issues remain when the question is quite novel. Last but not the least, they also say that when it comes to the legal profession, there are deeper institutional reasons which will ensure that, yes, A cannot completely supplant legal jobs. For example, as it stands today, we are still hesitant to leave the job of judicial decision making to a machine. All of us generally want a human being to decide on a case based on whatever is being presented before her or him. So there are institutional reasons also there. So what this MIT study is telling us is, yes, we don't need to completely lose hope. Another study, which again should be of some relief for us, is a scale lab study. Again, you will notice there one number, that is 0.37. And the interesting bit here is that for this particular study, therefore focusing on 2 sectors. One is finance sector, the other is legal sector. When it came to the legal sector, what made the study different is they used real life legal issues and asked the model to address or answer the question. And the interesting bit that is coming here is that even with extremely, I would say, advanced models, because you will notice here that the model that has scored the highest is GPT-5 Pro, and I can guarantee that no one sitting in this room has access to that model. But even the most advanced model could only score 0.37 when it came to complex real-life questions. Of course, with respect to the finance sector, they managed to score 0.40. But again, please do remember that these are with the most advanced models. So that is also very clearly telling us that, yes, across all the models that are tested, there are still struggles on multiple fronts, including, say, for example, transparency, auditability, handling uncertainty, and also domain-specific intelligence. The third and the final study which I want to show is from Harvard Law School. So Harvard Law School Center on Legal Profession also had released one report last year. And I thought that there was one quote from one of the interviewees in that study, which is something which everyone, including me and all of you, should actually be taking note of. And it is saying, and I quote, A may cause the 80-20 inversion, that is 80% of the time was spent collecting information and 20% was strategic analysis and implications. We are trying to flip those time frames. In other words, yes, during the earlier times, yes, 80% of your time in a job might have been for collecting information. You might have spent 20% for that proper critical analysis. But thanks to the advancement in technology, most probably we will have to reverse the time frame. In other words, you are going to spend 20% time in a task for collecting information, because yes, there are different ways to collect information so easily now. With one click, maybe with 1 second, you are getting all the information. But what is really important is 80% is spent on strategic analysis and understanding the implications. What does this mean in practical terms? In practical terms, there is a huge transformation that is happening today. For example, most of the studies that have analyzed the legal sector says that the role of paralegals and legal assistants are almost getting completely replaced, because that level work the current models can very easily manage. So we won't need paralegals. Even if we are requiring, maybe it will be like 1/10 or 1/100 of what we are currently having. Junior associates. Again, I mean, you all know that, yes, when you want to enter into profession, yes, you are entering as a junior associate. But what you should know is that this is going to get completely taken over by the machine. So what a junior associate might be doing today would in all probability be done by the machine. If you are looking at it in a firm-wise way, it is also very evident that the second tier and maybe third and fourth, all of them are actually going to struggle. Of course, for senior lawyers, be it in India, be it in other countries, or be it the partners in the top tier firms, they are more or less still in a secure position. But for all the others whom you are actually seeing currently on the screen, and of course I haven't put teachers there, I would say that a substantial chunk of teachers are also going to get replaced, and they should be replaced in this particular process. And this is a practical implication which all of us need to be recognizing and should be trying to address it. And how do we address it? To me, the only way we can address it is by enabling critical thinking through our education. But one of the questions which we'll have to ask, or two of the questions which we should ask, is how many of our institutions are actually moving in this direction? Or how many of our faculty members, and I am including myself there, are actually contributing in this shift that should be happening within ourselves? Now, how do we address it? Of course, I do understand that there are many challenges that are happening at multiple levels. There are challenges in terms of resources, there are challenges in terms of administration, but it is beyond doubt that we need to start addressing them. The most obvious, I would say, shift that is required, and maybe this is also the one where substantial, I would say, state intervention is required, is relooking at curriculum and pedagogy. As it stands now, we have a very static approach to what is a course syllabus, and we also have a very static approach to what are the evaluation methods that a faculty member should be using within a particular course. Sorry, this is not suitable for today's world. If we really want to enable critical thinking, which is essential for our existence in a world driven largely by AI, we have to see them as dynamic components, which also means we have to shift the power from most probably the university syndicates to college level. Within a college, the faculty members should be empowered to decide what should be the syllabus, what should be the evaluation approaches that would best facilitate critical thinking in that particular area. Second, faculty development and reorientation. Even today, a substantial chunk of faculty members are seeing themselves as information providers. I am sorry to say this, sorry, that role is over. Because even today, even before a faculty opens her mouth, a student can just put a prompt and then see what is the information existing with respect to that particular area. What is really important is turning the information received into knowledge. So there is a difference between information and knowledge. Unfortunately, the vast majority of faculty members are still focusing on disseminating information. And this very much connects also to the response which, or two of the responses which that law student gave me, because if students are not attending the classes, a part of the blame should also go to the faculty members. Because the students think that they don't really need to attend the class, they can very well get all these information in a much better way from all these platforms. So that is one. The second thing is, yes, as it stands now, we are only focusing on the end term exam. Again, the end term exam also is based on information rather than on knowledge in a particular area. So the faculty members definitely need to stop seeing themselves as information providers. Second is revisit the expectations. One of the things which we have to understand as a faculty member is that we shouldn't be expecting the best paper from a student, but instead what we should be looking at is what is the best paper which she or he can produce. Because to produce the best paper, there are large language models existing, but as a teacher, our obligation should be to ensure that she or he is able to produce the best she or he can. And that also requires, yes, changing the expectations generally in the evaluations. Last but not the least, yes, the students also need to get themselves reoriented. One of the most important qualities that is necessary in a student of tomorrow is resilience. If they are not able to adapt to the changing scenarios, sorry, you will be in trouble in many different ways. It is also extremely important to develop resistance against becoming a techno slave. So while I was preparing these slides, a kid who is in the 4th standard sat beside me, and then he asked me, Uncle, why are you actually wasting all your time in preparing slides? Why don't you just give a command on gamma? It can produce much beautiful slides. This is exactly what is happening today. Because there are different tools that will help us to offload our cognitive, I would say, activities. But the unfortunate reality, which all of us overlook, is that through that, we are also becoming slave to the technology. And our cognitive ability will be diminished substantially. And again, I don't have the citation here, but there have been studies that show that even within a small time frame as 1 year, apparently the effect of technology, the use of large language models on our brain are substantial. So to conclude my introductory remarks, what is really important is that we need to recognize the transformation that is happening, and we need to adapt to the transformation. What we all have to do, be it students, be it faculty, and be it institution, what we all need to focus is on developing critical thinking. And even if you are using AI, make sure that it is only complementing our cognitive skills, not substituting our technical skills. And don't misinterpret me as saying you shouldn't be using the technology. I am also someone who strongly advocates for the use of technology, particularly large language models. And again, I am saying it for a reason, because if you really want to achieve many of the objectives that are enshrined in our constitution, including, say, for example, making healthcare more accessible for 1.4 billion people, maybe we need to adopt technology. But in this process, we need to also ensure that, yes, we are not becoming the slave to technology. So with that, I'll end my introductory remarks, and I look forward to hearing your comments. Thank you.
Thank you so much, sir. From ARUL, sir, I would like to take the word relevant. So being relevant towards the upcoming AI models or digital methods, as well as us being relevant to the world. Thank you so much, sir. Thank you so much for the initial deliberation. I would like to now welcome Advocate PRASANTH. SUGATHAN. Sir, your experience in the legal practice would be of great information to us for this particular topic. Sir, welcome, sir. Welcome. Thank you.
Good afternoon, everyone. I mean, I would like to echo Arul's words. We were, he was in the 5th year and I was in the, 5-year batch, and I was in the 3-year when we were here. And all this is like pretty new to me. Like, I mean, we didn't have the facility of such a beautiful auditorium, a beautiful hall, etc. when we are here. And definitely congrats to all of you for organizing an event like this. At that time, I think we had a, let's say, a national level mood that we used to plan every year. In fact, we had worked together on that also at that point of time. So, but this is congrats to the Bhagat Singh Study Circle and College Union for organizing, doing something like this and inviting me for the panel. Thank you for that. Now, coming to this topic, I mean, I was introduced as a lawyer practicing at the High Court, but I wear different hats just to explain my interest in the area as such. I'm also, there's an organization based there's a non-profit organization based in Delhi called the Software Freedom Law Center. It's essentially a group of lawyers, technologists who come together essentially to protect rights of citizens in the digital space. And I'm the legal director of SFLC. So I'm involved in the policy side of these debates also. So, and again, I also have a tech background. I am an engineer turned lawyer. So I also tinker a bit with these, I mean, whatever software that I can work on. And so that is where I come from. So my interactions, my comments will be based on the inputs from various verticals and various areas that I work on. So there is one, definitely litigation, which is very close to my heart, which I do on a daily basis. Then yes, policy. That again is one area that we should debate a lot about AI. When we talk about AI, we are all, I mean, what I find now is people are in awe about this, like what is happening. There is so much happening around us, so much discussions about AI is going to change the world. Great. But regulation is also one area that we need to talk about. Now, have you heard of the Intel Corporation? I'm sure you have heard of Intel Corporation. The one who's one of the largest manufacturer of chips in the world, which powers our computer. And Andrew Grove, who was the CEO of Intel Corporation, he wrote a book called Only the Paranoid Survive. The wording is, the title itself is very interesting. It says, Only the Paranoid Survive. And he coined a term called strategic inflection point. There's a book worth reading. I mean, for your general reading, I definitely recommend the book. It will be very useful, I mean, for your, when you get into legal practice or when you do anything for that matter, the kind of perspectives that book gives is very important because it talks about how they reinvented the company, the organization as such. But what I want to focus on is the term strategic inflection point means when it comes to a company, an organization and verticals, industry, this is a major change which is going to shake the industry, which you cannot ignore and ignore at your peril. Now with AI, artificial intelligence, that is what is happening. We have entire verticals that are getting changed, entire verticals, entire industries which could change beyond recognition over a very short period. That is, I believe, what ARUL was also referring to when he referred to all those statistics. Definitely, it is also going to affect our legal profession and by extension, the teaching. That's the all the business schools, I mean law schools, etc. So definitely, we can't ignore it. But one problem here is, yes, we can see a technology, anything with how, yes, great. But we shouldn't also be slaves to the technology. One specific point which Arul mentioned, and which is definitely something that students, especially from a legal background, should be concerned about, is about how you will be dependent on technology. I don't talk about hallucinations, but that's just one part of it. When you are using technology and without even realizing it, you suddenly tend to outsource your cognitive functions, the functions that you would otherwise do as a lawyer, as a student, to this technology. So that is the thinking that you need to develop. This 3-year, 5-year term that you are in these law schools, that is where you develop these skills, your reasoning skills. When you get, let's say, a mood problem before you, the idea is to analyze what all things are there as far as that problem is concerned. It is easier for you to feed that to an LLM. And great, the LLM will come out with a lot of answers. But then, that is where you have lost. If you're going to outsource your work blindly to an LLM, then it will come out with great results. It looks great. I mean, you will have a paper within no time. But that is something which is going to affect you in the long term. I will also refer to a study which shows about how our skills are going to diminish over a period of time if we are going to blindly rely on this technology. I mean, my background is in technology. I am definitely not going to say that you should not use technology. Definitely we need to use technology. But how we use it, how we can make use of the technology and make sure that you are a master of that and not a slave to that technology is something that should be what everybody, I mean, when it comes to even regulation, that's something that we need to be careful about. Again, the other day, LiveLaw had an interview with Mr. Prashant Bhushan, and he was mentioning about how there are problems with the way judges are today, how there are biases, and how it might be better if we have an AI which decides cases. I'm sorry, I don't think we have reached there yet. The problem is we talk about biases when it comes to judges. What about biases when it comes to artificial intelligence? Now, again, let's say the cases that we get on a daily basis, each cases are quite different from what you maybe handled the other day. Maybe the judges would have handled different cases. I mean, you bring a new case before them. But then each case could be quite different from the previous one. And when we talk about ratio, when we analyze cases, you have one side arguing for it, the other side arguing for it. You have various ratios of judgments, which then you try to analyze whether this fits into this scenario. How can I improve on that? If you expect the AI to do this work for you, I think we will end up in a failure. Definitely rely on it, go for case laws, try it, use it to find better case laws. But if you are going to just rely on, let's say, maybe a Claude or a ChatGPT to help you out, I think that is going to be a mistake. There could be areas where AI could do great. For example, I was working on a privacy-related software. I wanted to create screens which could be used for me to explain this to the developer. Claude did just great. Gemini was superb. So I could create these screens, and that definitely is an area which I'm sure software developers, Indian software companies are going to definitely have a tough time. But I would say lawyers are safe to an extent, at least for now. But provided you don't outsource your work to the LLMs. Then there is one part of it which I think, as a person who graduated from a government law college, I do understand there are differences, the kind of infrastructure which is available here and the infrastructure which could be available in another law school, maybe a private law school or a national law universities. And AI here can be a great leveler, but not just in the teaching context, but AI also can be a place where there are great inequalities. Now we are in the phase where I would say the honeymoon phase where you get all these LLMs for free. The only thing is you give the data to them. That's a different context. That's a different discussion for another day. But then we are also now reaching a stage where you reach the, even if you have a paid plan with Claude, you reach the limits very easily. And you may not, even your institution may not have the resources to provide you with maybe the kind of access that you require to LLMs. So this is also a problem that could affect the way we maybe need to regulate these LLMs. We need to regulate AI. Because this should not be something which leads to more and more inequalities, and it should be something which leads to more of equalities. And again, this is another area that we work in, something called open source. When it comes to software, open source was one area where, which ensured that the benefits of technology were not restricted to a few. The benefits could reach everyone because of technologies like open source, which made the source code available to everyone and you could build on top of it. And that was the advantage of, I would say, the internet also. If you look at the internet, this was built on something called open technologies, open source and open standards. That is again something that we need to see when it comes to developments in the field of open source, AI, where we again want open standards, open source to make sure that it is accessible to everyone and there can be developments on top of it. Again, ARUL can talk more about the copyright part of it if required, but then that is one area again where we need to understand. Now coming to the policy part of it, the tech is one side of it, how you get access to it, but then we also need to look at how this can be regulated. If you look at the European Union, we have seen acts like the EU Act, AI Act being enforced there. Well, not yet, I would say, fully enforced. There are questions about, and there is now the amendments being made to it, move towards kind of diluting it. But then at least they are doing something about it. We are still in a stage where we don't have a law which is fully enforced on data which feeds these LLMs. And we haven't even thought about, let's say, regulating AI. So that is also, not everyone sitting here could be entering into, let's say, as a litigator. And you could be moving to other areas like policy. And this is also a discussion that we need to have. How are we going to regulate AI? How are the kind of discussions that we need to have? That is also something very important for a field like this. And when, especially for a student audience, when you have discussions, this is also one important area that we need to discuss about how this is going to be regulated. There are different views across the world. The US wants a more hands-off kind of an approach, and they don't want too much of a regulation and make sure that these companies can kind of flourish, come out with innovation. But innovation at what cost also should be a question that we need to ask. Again, for a country like India. Now, we definitely don't want a situation where we are fully reliant on all these big tech companies, whether it is OpenAI, Google, Anthropic, who decides the kind of tools that you use. And if we are just going to, let's say, build on these tools, that could also be a big drain on exchange. We now talk about oil, how this could be a problem for foreign exchange. This could also be another thing that we need to discuss, like when we have a situation where our economy is dependent on technology, economy is dependent on AI, how will the payout work? Then another side of it, with the environment aspect, that's also an area where a lot of discussions are happening these days. About the cost of something called the data centers. There was a report the other day which mentioned that around 6 to 7% of the US power production goes in powering data centers. Now we have data centers coming to India. I'm not saying that we should not have that. But there were reports the other day about data centers being established in Vizag, and this is being organized by the Bhagat Singh Study Circle. And so I think this is again one problem that we should discuss, with a large sections from the marginalized communities being displaced for these data centers. And unfortunately, not much of discussion happening. So these are, when we talk about AI, there are many questions which arise, not just about the technology, not just about, let's say, how it's going to affect the various verticals for that matter, whether it is software development or legal education, legal field as such, but then other impacts which will have on the society at large. So this is something that definitely we need to understand. Going forward, what should be the role of each of us, like as a society, how should we consider this, and how do we really make sure that we have strategies in place to regulate, and how do we get over the strategic inflection point as far as each vertical is concerned? Thank you.
Thank you so much, sir. Sir, I would take the note of AI can be a leveler, but on what grounds would be the question, and when AI become a leveler, how could like the countries like America or like the superpowers, who wants to be superpower, would be involved in those situations? And thank you so much, sir. Thank you so much for the initial deliberations. I would like to welcome Dr. Anish. Thank you, sir. Please.
So good afternoon to everyone. At the outset, let me thank Bhagat Singh Study Circle for inviting me to this program, because this is the second time I am coming here. Last year also I was here. Well, today we are talking about technology and legal education. What reforms we need in the present scenario. What is the aim of legal education? I think everybody knows that. Imparting legal knowledge and equip a student with necessary skills to join in the legal profession. Whether the existing system is sufficient, our legal education system is sufficient to equip a student confidently join in the legal profession. That is, immediately completing the LLB, when he is joining in legal profession, whether he is having that confidence. Now there is a saying, there is an age-old saying, whatever you are studying in law college or law school, that is not the real law. The real law you will learn only after practicing. Why? Because legal education will impart statutes, doctrines, principles. But when you join in legal profession, it requires application, client counseling, etc. So there is a huge gap between theory and practice. In this context, what I feel is technology can bridge this gap. Even earlier also, this gap can be bridged, but it takes minimum 3 to 5 years. As a junior lawyer, you have to join in a law office. So after 3 or 5 years, you will be equipped. But with the help of technology, I am confident once you come out of the law college, you will be able to equip with necessary skills. Moreover, there are predictions, as Arul sir was also pointing out. By the introduction of artificial intelligence tools, many of the traditional law jobs, many of the junior lawyers' work will be affected. That is true. Even I am part of one research team where we are trying to invent a AI tool. If it is successful, that is going to affect many of the junior lawyers. So in this context, how our legal education has to reform, I have few suggestions. So rather than any other thing, I will just focus on some suggestions. How we can reform the existing legal structure. First of all, we need to reduce the duration of the course into 3 years. I would say 3 years is sufficient to complete law. And we have to reduce the subjects maximum up to 20. No need to study more than 20 subjects. Only basic subjects. The remaining anyone can read and understand if you have the basics. Now, when you join in a law school, I would say 3 to 4 months should be spent to equip you with legal literacy. No need to teach any law subjects with up to 4 months. Teach only technology. I will tell you one simple example. All of you are using MS Word, either for writing assignment or for writing papers. How many of you have heard about justification or justify paragraph? How many of you are doing in MS Word that? Can you raise the hand? Very few. Very few. See, one of the very basic thing, but we don't know that. But you may be using it without knowing that. You are also doing it sometimes. The point is, we are all illiterate, in fact. Even though we are using many technology, we are illiterate. What I would say is, a law student should be made aware what is MS Word. What are the potential of MS Word? Unfortunately, even I don't know the exact potential of MS Word. I know only basic things which is required for me. But there are many things in MS Word. Many wonder you can do. That will make our job very easy. But we don't know that. Nobody is teaching us. And we are not trying to learn. So same way, there are many technologies. There are many legal databases. How many of us are using legal database? Sometimes we will go to Jester and we will give the keyword and find out what is required. And we will get 3-4 articles. There ends the use. But other than that, there are many ways in which you can use Jester. There are many online tools available, free of cost, which will enable you to do more and more research. Did any law college will tell you? Are you aware of this? Simple example, SSRN, Social Science Research Network. It's an online database. It's free of cost. Anyone can download any number of articles from that. But many of you are maybe not knowing that. Isn't it? So like that, if you go by World Legal Information Institute, there is another website wherein you can mine information. There are many countries tab is available. If you want cases from Kenya, just go through the tab of Kenya. You will get the judgments of Kenyan courts, which is not otherwise available in Google search. Through direct Google search, you won't get that. But if you go by this website, you will be able to know. So like this, there are many tools available in website, online, digital tools. And AI, everybody is using generative AI. Claude or ChatGPT or DeepSeek, Grok, many are there. But how many of us knows the exact way in which, how we can retrieve the data? Very few of us knows. We are all using ChatGPT. And anybody reads your content, they will make out it is made through ChatGPT. But there are ways you can create absolutely correct information. Though there are not some complex area, you may find it difficult. But for basic aspects, you will get correct information. There are many ways in which you can collect. But nobody is telling to us. So without knowing all these things, we are using this technology. So to avoid that, at least 3 months should be spent only to teach the use of technology. Second thing, application of this technology in your subjects. How different technologies can be applied in criminal law. What are the advantages or what are the ways in which a lawyer can use it? A student can use it. Judges can use it. Public can use it. Now see, when you are joining in legal profession, if a client is approaching you, when he raises some doubts or concern, you will give an answer. Immediately listening, he may be searching in the ChatGPT or some other tool, whether you are saying is correct or what more can be done. So you should be equipped to deliver something more than what is available in digital tool to the public. Otherwise, public don't trust you and you will lose your name. So the law school should equip the student to know how to use this, how public is using, and how it can assist a lawyer in legal profession. So this should be taught in the beginning. So that is very essential. Without doing this, whatever way we are going to reform our legal education, it is not going to benefit you. Simple thing, again I will tell you, everybody is using smartphone. You all having smartphone. How many of you know the 100% use of smartphone carrying by you? There are many tabs installed, pre-installed applications. How many of you know how to use it? What are the real use of it? Nobody knows. Even I don't know. Maybe very exceptional people know. So what I was saying is, if you want to take the benefit of, if you want to tap the benefit of technology, we should make them aware what is technology, what is the way in which it can be applied in law. That is the first thing. So initial 3 months or 4 months should be dedicated for that. Second thing, do away with examinations. No need of examinations. The physical writing examinations. I am totally against that. In this digital world, it is just a mockery. Again, what is required? We have to have a two-way approach of teaching. One level, you have to explain the theory. Second level, you have to explain the application. There, all these technology will help you. You might be heard about the introduction of a virtual moot court room by GNLU, Gujarat National Law University. They have introduced a concept of VR, virtual reality, for moot court activity. Like if you want to go for a moot court outside, you can present there. There will be a tool. That tool will act as a judge. And it will correct how you can argue. So you will get a first-hand information. And you will be able to correct. And then go to the original moot court. So like that, tools can be used. There are many ways in which. So rather than teaching subject, just introduce the subject or topic theoretically. Then next day, you apply that theory in practical sense with the help of tools. There are many institutions where problem-based questions are there. And students will always argue. These problems are not taught in class, then how this question coming in exam? So rather than only including in exam, include it in the classroom. Say for example, if you are studying trespass, tell what is trespass, ingredients and everything in within 20 minutes. Then give some circumstances. Ask the student to apply it. Now interesting thing, after 3 days, you can have an online exam in an application level. So students will prepare that topic within 2 days and they will apply it. So conduct online exam only with the help of digital tools. So then and there evaluation will be over. No need of annual exam or semester exam, nothing like that. Conduct every 3rd day exam. Then after that, once you, suppose if you are not able to get the good score in that exam, you will be asked to give any number of exam. You can write any number of exam. And whenever you will clear, then only your certificate will be given. So the student will be interested to study more and more because he need to finish at the earliest. And if it is online exam, if we are using this AI tools for evaluation, and if it is practical oriented, the students will learn how to apply whatever they have studied in a real lifetime circumstance, so that they knows everything before entering into the legal profession. Now, when I am saying this, you will think, is it possible in our country with this infrastructure? Our many colleges, schools, everywhere, infrastructure, digital divide is present. I would say it is possible. It is not an insane idea. Recently, I met with one of my friend. He asked me, can I design a website to you? I was wondering, because he's a law background person, a lawyer. He is asking me, can I design a website to you? Then I asked, from where you learned it? He said, I attended a 3-day course. 3-day course. And the 3rd day, we could design a website. So only 3 days he attended a course, and the 3rd day, at the end of the course, every participants were asked to design a website. And he did it. How it is possible? If that is possible, even for a law student also, after learning the theory, after applying many practical situations, when a client approaches and explains his problem, easily he will be able to answer. And he can take the help of any digital tools, be it AI, whatever it is, let him take. But he will be able to provide an answer. And it is not the case, your wisdom you have to replace with AI tool. Because AI tool cannot give you better idea. If you are having better idea, then only AI tool will give you best idea. So since everyone is using AI, who is using in a best way, they will get preference. So this is what I wanted to tell you as an introductory remark. So we have to transform our legal education in such a way, rather than going with the existing system and asking students to use all this technology without knowing what is it. Thank you.
Thank you so much, sir. Very interesting deliberations on academic curriculum changes. Thank you so much for your deliberations. Sir, I had also had to face a situation where you had explained the necessary teaching of the, like, not of any AI tools, like simple tools like MS Word. So I have been attending an interview to University of Southampton. So as a contract manager, that was the position they were interviewing for. So they simply asked the question of, do you know a software known as WorkTribe, or how fast you can type in MS Word. So these are the interesting questions which have to be faced by a lawyer or a law student who is just graduating out. So I don't think when we are talking about the AI incorporations within the legal system or the legal pedagogy, we will have to address these issues as well. Thank you so much for your time, sir. Thank you so much. Right now we will be having half an hour more, so we would like to open this floor for the questions of students. For me, before moving on, I would just like to, so from Anil sir, it was a very different thought process and introduction of a new strategy for curriculum. So I would, being a professor from the top law school in India, sir, would you like to adopt such curriculum towards your institution, or are you on a different stage compared to what Anish sir has introduced, or you have different methods of pedagogy so that such things have been incorporated with your institution?
Thank you for that interesting question. So at NLS, we have been, I think, constantly deliberating on the challenges posed by AI, and we have consciously taken some steps. So for example, now it is a mandatory thing for every faculty member to decide before a course whether AI-based submissions will be allowed in that particular course or not. So the default position is no AI use is permitted, but of course if the pedagogy demands it, we are allowed to do it. For example, in my course on comparative copyright law, which I teach with Harvard Law School, we have consciously allowed students to use AI in their submissions, but of course with some very strict conditions. For example, like what we generally do to avoid plagiarism, we mandate that they have to disclose the use of AI very clearly, suggesting specifically in what way they use. Did you use it for brainstorming? Did you use it for paraphrasing? Did you use it for grammatical corrections and so on? So that's one limb of it. The second step which we specifically took was they have to also cite the particular model. The third thing which we also did was they have to also underline the parts for which AI-based submissions have been used. But what I'm trying to say is that, yes, we have started taking steps, and if you look at most of the leading institutions across the globe, you will also notice that there are no concrete or set answers in this particular area. So every institution is trying to learn from experiences and then try to adapt themselves into the emerging challenges. I just want to cite one example there because again I see that there are not just students but also people who are heading institutions here. Berkeley Law School very recently as like last month, completely changed their student AA policy. So previously, like many of the other institutions, they were also allowing the use of AA. Now, in the latest policy, which was released last month or in last 2 weeks, they have said AA cannot be used at all. The only use for which it is permitted is something which Prasanth was also mentioning earlier. That is, you can use it for searching case laws or references. You have to stop there. So even for brainstorming ideas, even for making grammatical corrections, the new Berkeley AA policy is saying you are not allowed to use it. Again, in Berkeley also they said this is a default position, but if a faculty member wants to use it for pedagogical reasons, yes, they are allowed to use it. But yes, then it would be the responsibility of the faculty member to also prove that, yes, this is in line with her broader pedagogical goals. So, in a nutshell, yes, we are taking the baby steps in this regard, recognizing the transformation that is happening.
Prashant sir, so regarding the same question, so you were talking about the policy changes and the need of data protection. So in case like we are allowing or we are moving forward with a new curriculum for a legal pedagogy, like introducing AI models. So in your vision, like in 5 years, that would be a great there would be a great change in our legal system and as well as the legal pedagogy. What would be the greatest threat towards the regulation of our country regarding AA? Because even law schools or other institutions would be incorporating AA to the system. So what would be the regulatory challenges before our country as well as before, as a lawyer, what would be the challenges for a practical aspect as well? Can you please?
Coming to the question of regulation, that's from a country perspective. So that is where we need to look at it from the question of harm. What is the harm that the technology could cause? And that is where the regulation needs to step in. So there are some areas where it has to be a complete no. We cannot have AI in that area. So if it is that, let's say the technology being introduced in that area, if it's going to harm a citizen, in any way, there could be various methods. So in that case, it could be should be a complete no. So for example, facial recognition may not be like a full case, but the facial recognition for some use cases need to be like completely stopped. So for example, in a classroom, if you are going to, not just a classroom scenario, but where you are, for example, if you are going to evaluate the emotional, let's say, what a student is doing or what a person who is being surveilled is doing, if you are going to look at those aspects, then it could be a complete no. The various ways, it has to be a graded approach. Some you can permit, some you need to have a complete no. And that is what let's say EU is trying to do. And there also has been a pushback there from the industry, and things are being kind of diluted as of now with the new omnibus law which is being introduced now. Like we not finalized as such, but that is the position even in EU, where it has been all pro-privacy, and that was the approach of the EU. But even there has been a pushback from the industry. Civil society is voicing their concerns about it, but that's happening. And what we are seeing in India is, we had initially there was a lot of push as far as AI is concerned. There is then what Niti Aayog is doing, what India AI mission is doing, etc., where we are coming up with mostly guidelines. And these guidelines are essentially, like any guideline for that matter, these are not enforceable as such. So you can't have a law which is like a loose law where we can say that, okay, you follow if you want to do, otherwise it is okay. That cannot be the situation, especially when the use of the technology could lead to harm. So that is where we need to have a proper way of regulating the technology. See, you can't just, by giving the excuse of innovation, by permitting innovation, you can't, let's say, for example, atomic energy. You had strict laws as well how, you could use atomic energy. What could be the ways in it which it could be done. Same is the case here. When there could be a harm which could be caused to citizen, you need to have regulation in place. There cannot be a second, let's say, answer to it. Like there can't be, it has to be very clear on your part. So same when it comes to, so definitely we will see that over a period of time. It can't be a, let's say, a free-for-all kind of a situation. I'm sure that our country will also come to that stage where there will be regulation. Now, as far as let's say the teaching aspect is concerned and about regulation in that area, I think we should all expose our students also to what is happening in other countries. It's not just what is happening here. Again, when we talked about privacy, we were discussing about GDPR. We're discussing about what is happening in other countries as such. And that is where we need to have a comparative study of what other countries are doing. And we generally develop our law, our jurisprudence also based on that. So that is what I think we should incorporate in our teaching, our pedagogy. Look at what other countries are doing. Look at what the jurisdictions who are doing it. I would say when it comes to privacy, I would say EU is a better example than the US. So that is where the comparison should be, and that is where the study should happen. And yeah, I think that should be the best approach as such.
And sir, I would like to ask that, sir, very interesting deliberations I have already. Sir, what would be the challenge to you if you are the person who would like to introduce the concept of new curriculum, and so you would be facing a lot of people in the sense like maybe of your age, or maybe people who are like in age of your own, or like very younger age students. So what would be the biggest challenge, and what would be your the pivotal point to make them convinced that whatever you have explained would be the best option for the students?
So, well, in my suggestion, I said, is it a sane suggestion or insane suggestion? See, when calculator was introduced, there was a huge protest against calculator in US by mathematics teachers. It was a very huge protest. Now, after some times, calculator become part of our life. Nothing happened to mathematics. So, likewise, if you use AI, or any technology, whatever way we are going to resist it, it will become our part of life. No doubt in that. But the problem is, when you increasingly depend on AI, unlike other digital technology, individual creativity is going to lose. Individual knowledge is going to suffer. What I am saying is, earlier, when I was a student, we don't have this AI or anything. So when we get an assignment topic, we will go to the library. We will identify some 5 to 6 books and articles. Then we will take one paragraph from one book, another paragraph from another book, another from article, then a conclusion from another. This is the reality. I know everybody might have done this in our generation. Then we will make it in a order. So this was our assignment. Then what was happened? Plagiarism software came. So they started catching it. They will easily dictate, okay, this is plagiarism. This first paragraph from this, like that. Now what we did, we used paraphrasing method. We started paraphrasing it. So once we started paraphrasing it, plagiarism software cannot catch us. Now, but at that level, up to that level, we ourselves is finding the relevant book, relevant paragraph, and we are making the arrangement. But now when AI is being used, what is happening? Nobody is reading the books. They will simply give prompt to AI. AI will generate some content. And whatever AI will generate, that will be considered as final and will be submitted. This is going to affect your learning and your creativity. Because earlier when we cut copy pasted from different books, it was our intellectual creation in fact. We identified relevant book, relevant page, relevant cases, then we tried to put it in an order. So we got all the knowledge of that component. But now when AI is creating, you don't have any knowledge. You are simply getting it within 1 minute, and most of the case, those who have used, I am sure you might have not read that document. You simply copy it and submit it. Think yourself, have you ever read what is created by this AI word to word and try to correct? No. You just copy paste, you add your name and submit. So the problem is your individual knowledge is not there. There is no development with knowledge. So what is the solution? The solution is you use AI as an assistant, like a teacher, not to replace your thinking. What is this? I will tell you. When I was a student, when I used to write an article or when I was writing my dissertation or thesis, some point I will not get any idea how to move further. So I will go and ask my senior teachers or seniors. So this is the thing I written. What can be written next? Then they will give some idea. So after listening their idea, I will find out an option or I will get something, then I will continue. So same way you do yourself. When you are getting stuck, use AI to get some an idea, not to write content, only to get idea. So use it as an assistant. And second way, you find out all the materials for yourself, you write yourself, then ask AI to modify it, rearrange it, paraphrase it. Then the interesting thing is your write-up will be very good and you will get the knowledge also. Because nowadays many journals, they allows use of AI to the extent rearranging or paraphrasing. So you are not creating content. You are using AI only for paraphrasing it or putting it in a structure. So you will have the knowledge plus your work will be very good. Just like your senior teacher will read and correct in the first level. Earlier they used to do the same. So instead of giving to them, you ask ChatGPT to correct it and make it in a structure, whatever you have written, not written by AI. So this way if you can use, you can take the benefit of AI. Otherwise, you will not have any creative thinking. You will lose your knowledge. Now when I...
When you approach your teacher, not multiple sittings, so having the teacher is the... And if the teacher is so generous in accommodating your doubts, etc., then in all these sittings, in each of this sitting, there is a learning content for you.
Exactly.
There's a learning content for you, where you after one sitting you then you rearrange it, or either there is an amendment, there is something that deletion, additions, etc., or an analytical point that the teacher want to make you to, not that the teacher is applying the analytical point. So how will you connect it? What could be the way in which you can connect it, etc., etc. But then each of these sittings, the content, the knowledge flow from the teacher or that guidance is there. When you simply create a content and ask the AI to rearrange, paraphrase it, etc., etc., whether the student is going through it for a second time, how the change has been effected, in what way your intellectual product has been renewed or rather value added, if that is not there, then there is no connection between the final product and this particular student, and the student will find it very difficult to justify when he is being propped.
Exactly. See, I'll tell you the reality. even in my time, when I used to go to teacher will make many suggestions and teacher will write many comments over it. And those who are in that generation, they know how many suggestions we have really incorporated. If you ask that generation, we won't incorporate everything. We will incorporate only those suggestions which we will be able to incorporate. This is the reality. But, yeah, exactly. Exactly. We will be caught. We will be caught. We will be caught. The point is, it is our responsibility to make our write-up more and more depth and more research oriented. So we have to use this technology in such a way so that we can make it very in-depth research oriented write-up. Now, one problem what I am facing now is, we are saying we can use AI and some institutions are prohibiting AI. Now, if a student uses AI, what can be done? You can use plagiarism software like Turnitin Authenticate. That is the software now available. Using that, you will be able to identify AI writing percentage. You can dictate how much percentage is written by AI, which are the sentences written by AI. Now the problem is, there is a software, or there are many software which is even freely available, AI Humanizer. You can humanize this AI writing in using that software. None of the present software, plagiarism software, can detect this as of today. Now how you will be able to identify whether it is created by AI and humanized it? It's a challenge. It's a real challenge as of now. Everybody is facing. Even I am also facing. I used to say to my students, don't write with AI. But they will come with humanized version. How I will prove it is written by AI? I can't prove. So this is the real challenge. Second challenge, as the moderator was speaking, if we are going to introduce this, many resistance will be there, because there is a generation, or there are people, they are not ready to change their mind. We have to change their mind first. See, why I am saying, why the cyber crimes, financial frauds are happening in our country, at least in Kerala. Kerala is ranked as the third state in India where large number of cyber crimes are happening. And which are the cyber crimes are happening? Financial crimes. Why it is happening? Not because of any technology. The fraudsters are not using any brilliant technology or anything. They are simply calling and saying, we are from such and such bank, give me your OTP. Immediately this person will give the OTP and they will take away the money. Why it is happening? It is happening because of the ignorance of that person. Many times people are not aware of how to use it. So that is why I am saying, if the students, at least law students, are inculcated with all the general basic aspects of technology, they can perform well. They can take the benefit of this. Many technologies are available, even for designing. Like, simple, suppose this program you are organizing, you might have spent lot of money for designing this poster. Now, with the help of AI, within 2 minutes, if you have all the photo, you can generate very beautiful poster. We can cut short lot of money and time. Yeah, maybe, I don't know. But there are many people, they don't know how to use it. So what I am saying is, this is something very essential. I would say it is not only to law students. In every curriculum, at least 2 to 3 months exclusively for teaching law. Teaching technology. Not only AI technology. AI technology is the latest one. Starting from operating the computer, mobile phone, MS Word, PDF. Even there are many students, they don't know how to convert PDF, a Word to PDF and PDF to Word. And there are many students, even now I am seeing, they will take photo from the screen or they will take screenshot and they will type down looking at that. But there are many applications available, or even ChatGPT will help you. Just upload that image in ChatGPT. ChatGPT will extract entire wordings without any mistake. So within seconds, whatever be the number of pages, you will be able to extract it. So this way, it will help the law students in to reduce time to perform well. So that is why I was suggesting this reform.
Thank you so much, sir. We might be in constraint of time. I would like to place this slot to be open to questions from the audience. So please, yes. Please move yourself to the front so that you can comfortably ask the question through the microphone, please move forward. Thank you. Please name the person who your question is to. Thank you.
Good afternoon, sir. My question is to Dr. ARUL George SCARIA, sir. Yes. I'm assistant professor at Alliance University, myself and CP Andrew. So we are actually staying in a world where we cannot actually tell that we are completely negating the AI. And we know that its interference is there. So when it comes to AI, as per the report which you have actually discussed, the Harvard Law School report, they are actually also telling that when it comes to the AI, it is incapable when it comes to the extrapolation of the morality as well as human intent. Despite that fact, we know that when it comes to our profession as law students, it's actually rewiring their profession. My question is that how can we actually modernize our curriculum so that we can actually ensure that our students are having that context engineering skills. And also I have one more connected question. Now we know that our students are also relying a lot into the AI as well as the information from there. Now the kind of information, whatever that is being received by the students, we could see that there is a majoritarian bias over there. So my question is that from this learner helplessness as being cited in the Harvard Law Center report, how can we ensure that our students are not falling into that particular learner helplessness? Thank you, sir.
Yeah, thank you for those two interesting questions, and to me at least they are also very much interconnected questions. As I also mentioned during my introductory remarks, I think the most important thing which we need to keep in mind while designing the curriculum is this a curriculum that is going to enable critical thinking in this area? So be it your readings, be it your classroom delivery, be it your evaluation, for each of the components that are becoming part of the curriculum, you have to carefully ask this question. If any of them is not serving that purpose, that means yes, it's not suitable for this age. We need to revisit it. As we also discussed earlier, it is beyond doubt that information extraction has become so easy, but as you also pointed out in your second question, a lot of information which people are receiving today are either junk information, absolutely worthless information, or biased information. Of course, you pointed out to one type of bias, that is a bias towards majoritarian views, but maybe I also want to point out another more severe issue, which is also very much connected to the interesting dialogue which Girish sir was having with Anish. That is, many a times these platforms are reconfirming the views within ourselves. So imagine that my view is X with respect to a particular issue, and I try to ask ChatGPT or any of these large language models, is this view correct? Studies have pointed out that they tend to align with us and then thereby also make it even deeper within us. So this is called the confirmation bias challenge. And this is very much different from the discussions which we were earlier having with teachers or whoever it might be, or the senior lawyers in the field. When a senior lawyer is hearing an absolute rubbish argument from our side, they would say this is absolute rubbish, you need to actually revisit your argument. But when we are giving this prompt to the AI system, almost every study says that almost all the large language models which you saw earlier on the screen, all of them will say, yes, this is a wonderful idea, go ahead. And this is a deeper bias issue which I think most of the people are now overlooking. From a pedagogical perspective or from the broader education perspective, we need to address this issue very, very firmly. And I will also then connect it with one of the issues which Prashant was mentioning here earlier, that is the harm issue. Of course, there are some harms which are very visible, but we should also start deliberations on maybe invisible harms that are happening. So when I mentioned or when I discussed some of the issues earlier, I mentioned that a 4th standard student told me, Uncle, why don't you make slides with gamma A. Again, we have to very carefully ask, should we allow the use of these AI tools for kids below a certain age? What implications are these large language models causing in their brain? Unfortunately, within our country, there is no deliberation on these issues, and most of the schools, while they say that they want to ban mobile phones, they are actively allowing students to use large language models like ChatGPT and so on. This is going to destroy a generation completely, and these are the kinds of harms wherein we need far more deliberation.
Can you please move forward?
Hello, sir. Hello, Arul, sir. Hello, Anish, sir. Sir, I have a question to you, sir. Arul, sir. I happened to attend one of the lectures recently offered by one of your colleagues, Dr. T.S. Somasekhar. Sir actually used this term called agentic AI. Employment of agentic AI to conduct analysis at a higher levels. Now, we discuss about larger language models. Now, agentic AI has further threats, sir. And secondly, you use the term algorithmic biases. Now, if you use such algorithms in legal systems like criminal adjudication, what are its potential impacts, sir? Because AI is again, the algorithms are again operating in a black box, and you really don't know how the outputs are coming. You know the input, you know the output, but the process behind it is very mysterious. So these are my questions.
Could you please introduce yourself?
Yes, sir. My name is Keshav Prasad. I am a fourth year law student from the Tamil Nadu National Law University.
Very, very interesting to see that students from other law schools are also attending today's session. I wasn't aware of it. Again, I mean, two great questions. So one thing, we all talk a lot about large language models, but as we can very clearly see, the application side is moving very, very fast. So today AI is used to complete many transactions. Of course, some of them we are consciously aware of, but there are also many transactions that are happening in the background which we are not aware of. So definitely there needs more deliberations on agentic AI. That's a very clear thing. The algorithmic bias issue, again, as she was also trying to point out, there are serious issues if you are deploying AI for many of the things in the legal realm. For example, if you are using it for judicial decision making, it's quite evident that yes, we have to also very carefully check whether there are potential issues of bias. Most of the studies indicate that yes, there exists different kinds of bias. It could be religion related, it could be race related, it could be caste related in the Indian context. There could be n number of biases. And unfortunate reality is that most of the AI models do not give you access to the complete model as well as the data set on which it has been trained on. So Prashant earlier mentioned that yes, we should also start in parallel deliberations about open source models. And unless and until we have pure open source models wherein we can check for these biases and then try to address them, yes, we have to be very careful in terms of the deployment of these tools. Maybe Prashant might also want to add on this because he is someone who is actually working in the field in this particular area.
Yeah, I mean, specifically on agentic, yeah, there are quite a lot of issues because the kind of access that agentic AI will have to your systems, and with essentially like somebody assisting, I mean, or acting on your behalf. So that again is one area where we need to be careful about what kind of permissions are given, what kind of security is inbuilt. So a lot of issues, I mean, as far as agentic AI is concerned. And again, algorithmic bias has been something which has been debated for long about how these models are trained, what issues are there. And again, I earlier mentioned about Prashant Bhushan's interview where he was talking about bias of judges, etc. But this is also, when you are going to use AI for finally something like judicial decision making, definitely it will have a problem about the kind of data that is fed into it. And there has been a lot of researches about the kind of bias. For example, when it comes to employment decisions, like whether somebody who should be employed or not, which area should be surveilled. We have seen the traditional biases creeping into AI systems also. So biases based on races, all this. These also creep into AI systems. So these have been documented. This is out there. Like these are problems which we can see from the data that has been fed into AI. So any biases that humans have, these systems will definitely have. So those are things which we definitely need to be careful about. Now yeah.
Actually, I had a question, but I think sir is yet to answer my question. I think you are yet to complete your answer.
No, go ahead.
Yes, sir. So, Anish sir, you happen to mention about Turnitin AI. Now, I have a fundamental confusion. Whether Turnitin as a software detects plagiarism or does it conveys the similarity levels? Because they are two different things. And similarity levels, when I have observed it a lot of times, it even shows conjunctions like the, Now, how on earth can I complete a sentence without a conjunction? If I remove a conjunction, that too, when I am writing a legal paper, the meaning and context could change. And such words are being flagged by such AI platforms. Take Turnitin for example. Now, a young researcher who is in his first or second year might just get panicked because universities prescribe, I think TNLU prescribes 24%, excluding all the references. At 24 up to 26-30 it's fine. Beyond that people panic. So how do we distinguish there? How can faculties distinguish whether it's plagiarized or similar? Because they are different things.
See, it is the way in which how we are going to use this turned in. In turned in, there are options. When you are uploading a document, you can specify what all things should be identified in that. Like how long the words, like 3 words, 4 words, you can exclude. Even if 4 words are similar, it can exclude. There is an option. 5 words you can make it excluded. 6 words you can make it excluded. You can exclude prominent cases. So you can add, there is an option to add this. So when I am searching something, when I am uploading a document, I will fix all these criteria. So there is no question of, like Cochin University, everywhere you will have that name. Whoever will use it will be like identified as plagiarism, but I will make it as an exception. So wherever Cochin University is mentioned, it won't be catched as plagiarism. So like that, the software allows us to set the parameters to find out the similarity. So if you are using that, this problem is very well overcome. Yeah, that is their problem. It's not the problem of the software. That is what they are not digitally, they are digitally illiterate. That is why. See, even I have also faced the same thing. When I am submitting some article, my name will be considered as a plagiarism. My name is identified as plagiarism. It happens because they don't know how to use that software properly. If they know that, they will exclude all, they will set all these parameters of exclusion, then there won't be any issue. So this is the issue. So don't get panic. You tell them to use the proper way, how to use that software.
But again, maybe I might have a slightly different perspective on this issue, and I'm again mentioning it for a reason. I notice that many universities in Kerala has a very specific percentage permitted as plagiarism percentage. For example, I think University of Calicut 20% or something is what they have mentioned for PhD submission. And the worst thing that is happening is, who is actually doing this check? And in many of these universities, I notice that it is a librarian who is doing it. This is absolute nonsense which has to stop immediately. Whether something is plagiarized or not is something that has to be determined only by an expert in that particular field. For example, if I am writing something on constitutional law, if I am writing a PhD thesis on constitutional law, I might actually quote maybe 2 paragraphs from Ambedkar, and the same might be cited or is contributing to the similarity. But no sane scholar in this world will say that that is plagiarism, or should be saying that. Unfortunately, the machine cannot do that. So that precisely is the reason why no institution should go by the similarity percentage. Even if we are excluding through whatever things which are options available in Turnitin, or for that matter any of the software plagiarism thing, the decision making has to be rested with a human reviewer only. If our universities are continuing to do this, sorry, we are actually doing a serious disservice to our society. We need to actually, these are the places where we need to understand that humans should never be replaced. The final authority on these type of questions should only be a human being.
Just adding to that, see, don't get panic about plagiarism or plagiarism software. Even before the introduction of plagiarism software, our teachers used to say this is copied. You know that? Because when I was a student, we don't have any plagiarism software. But the moment I will submit something, my teacher will say this paragraph is not written by you. The reason is, when a teacher reads a paragraph and goes further, he can easily identify whether it is written by the student. Because if you are copying from different sources, it will have different sentence construction. It will have different accent, different uses. So by reading that entire document, if it is a good teacher, easily make out, even without any software, what is plagiarized, what is written by you. So don't get panic about that. Thank you.
I think we would move forward the conclusion. Oh, yeah, please. This would be the last question. Thank you.
I am Advocate Shyam, a practicing lawyer, PRASANTH sir, because I am hoping that there will be no AI judge like you. But two recent things in Kerala, the family court judges, cases were calling before a CMO, Chief Ministerial Officer. The work was delegated to some offices. And after introduction of e-filing in Kerala High Court, the filing scrutiny officers are deployed. And for scrutinizing bail application, there is AFSO, I think. So, so there will be a time. We will not. There will be time. There will be some AA judges. For that, I am suggesting some points. There are some stereotypic matters in Kerala High Court. We are getting installment facility in surfacing matters, appeal pending matters in tax matters, surrendering before the court and let the magistrate consider the bail application. There are so many such things. Same thing in lower court, petty motor vehicles things. Those things can be done by an AA judge. And succession OP, there will be no such decision. So, there will be chance for that aspect also.
Yeah. So these are things which are developing over a period. I mean, even when it comes to installment matters, we have seen judges using their discretion, figuring out whether the kind of, based on the facts of the case, based on the financial situation of the person, how installments can be given. But you can't expect an AI to empathize. So that is one quality the AI, us at least, doesn't have. When it comes to the next stage where we move from AI to artificial general intelligence and all that, and that is a different stage altogether, where AI starts thinking more like a human. Yes, could be that. I'm not discounting that we won't reach a stage where we can't have, let's say, an AI judge or an AI deciding on judicial matters as such. But I don't think the stage is ripe as of now, is what I feel. And then, yes, technology would improve. But then, when it comes to complex situations, definitely, I think, I'm not sure, not someone who can predict maybe what it will be like 10 years now. But at least as of now, with the technology we have, I don't think we are ready for that yet.
Thank you, sir. Thank you. Thank you.
One last comment, since we have students here, this is kind of taking this as a closing statement. See, one problem that we have that has been highlighted is how it could affect our profession, how it could affect the legal profession, how there may not be junior associates and not many job openings for you. But one positive, I would say, with AI is there are a lot of openings which are happening in the area of data, that is data privacy, data protection, and AI governance. So there are openings, new avenues which are coming up thanks to AI. So please look at that also, not just the traditional job avenues. Looking forward. Thanks.
Thank you, sir. So we would move to the conclusion. I would conclude that let any prompt or any of those or AI comes to your life or be a part of your life, but it won't affect your ability to critically think. I think as students or as humans, the ability to critically think and put forward something which is our own is the best quality we should have, and we should move forward with it. And thank you so much, and I congratulate the organizers for giving us this opportunity, and thank you so much for the panelists. Thank you, audience, for being such a wonderful audience. Thank you so much. We conclude. Thank you.
Thank you so much, sir. That was absolutely an insightful and visionary discussion. On behalf of the entire institution, I extend our deepest gratitude to our moderator and our brilliant panelists for pulling legal pedagogy out of its conventional shells and showing us the bright digital horizon ahead. Let us give them one more huge, resounding round of applause, ladies and gentlemen, please. To honor their presence and contribution, I now most respectfully invite Dr. Anushree A, Faculty of Government Law College, Ernakulam, to kindly come upon stage and present the mementos to our distinguished panelists as a token of our appreciation and gratitude. Ma'am, please. Ma'am presents a token of gratitude to Dr. ARUL SCARIA, Professor of Law at the National Law School of India University, Bangalore. And next, she presents the memento to Advocate PRASANTH SUGATHAN, a premier technology lawyer practicing before the Honorable High Court of Kerala. And next, we present the moment to Dr. Anish P. Pillai, Associate Professor at the School of Legal Studies, QSAT. And now, we present the moment to Advocate KURUVILA SABU CHRISTY, the moderator of this session. Thank you so much, ma'am. As students of law and guardians of the Constitution, we recognize that dissent, freedom of expression, and accountability are the very lifeblood of a thriving democracy. To formally move a vital resolution on behalf of the College Union 2025-2026, standing firmly in defense of these constitutional values and the dignity of democratic dissent, I now invite Anjana P.S., a first-year student of the State College, to the stage.
Resolution. The National Conference on Shaping the Future of Legal Education, Innovation, Practice and Reform records a strong criticism of the derogatory characterization of unemployed youth, RTA activists and media persons as cockroaches. This conference affirmed that it is these very cockroaches who dare to question authority and demand accountability from the powerful. They are not a menace to democracy, but its conscience keepers whose voices sustain transparency, accountability, and the rule of law. The conference further condemns any attempt to block or restrict social media platforms and accounts that criticize these derogatory remarks or express dissent against the current political dispensation, as such action undermines the fundamental right to freedom of speech and expression guaranteed under Article 19 Clause 1 Clause A of the Constitution of India. The conference therefore stands for and call upon all institutions to uphold the dignity of dissent, the freedom of expression and the constitutional values that sustain our democracy. National Conference 2026, College Union 2025-26, Government Law College, Ernakulam.
Thank you, Anjana. As this panel session drew to its official close, it is time to formally record our gratitude to everyone who made this academic session possible. To deliver the official vote of thanks, I invite Alex T. Reggie, esteemed union member of the College Union 2025-2026, to the podium. Alex, please.
Respected panelists on the dais, our moderator, esteemed faculty members, members of the media, and my fellow student friend. Good afternoon. As we come to the close of the session, it is my pleasant duty to express our sincere gratitude to everyone who contributed to the success of this panel discussion on the topic Law, Tech and Education Reforming Legal Pedagogy for the Digital Future. We extend our sincere gratitude to our distinguished panelists for sharing their time and expertise with us today. Dr. ARUL SCARIA, Professor of Law at NLSIU, thank you for bringing your exceptional academic rigor and deep legal insight to this discussion. Thank you, sir. Dr. Anish V. Pillai, Associate Professor at the School of Legal Studies, CUSAT, thank you for breaking down complex legal framework into such clear, structure and actionable concept. Thank you, sir. Advocate PRASANTH, SUGATHAN, Advocate at High Court of Kerala, as a specialist in technology law, your sharp commentary, balanced the perspective and excellent time management ensured a cohesive and highly engaging session. Thank you, sir. We also place on record our appreciation for our moderator, Sri KURUVILA Sabu CHRISTY, Assistant Professor at St. Dominic College of Law, Kanjirappalli. Thank you for highlighting the foundational and practitioner aspect of the subject so effectively. Thank you, sir. Finally, thank you to our audience for your active participation and to everyone who worked behind the scene to make this session a resounding success. Thank you.
Thank you so much, Alex. Now, we will be distributing the certificates for the participants of the paper presentation. I kindly invite Dr. ARUL sir to stage to provide